What we're witnessing is Donald Trump watching federal marshals begin the process of taking control of his properties. And the judge overseeing the case didn't merely turn aside his legal arguments, she dismantled them piece by piece, issuing a ruling so severe that legal analysts are calling it one of the harshest opinions ever leveled against a former president. The spark for this financial unraveling came from Trump's own legal team, who filed emergency motions arguing that the asset seizures were unconstitutional, that the fraud judgment was politically driven, and that enforcing it would inflict irreparable damage on his business empire. The judge's reply was blistering. She labeled the arguments frivolous, devoid of legal merit, and an affront to the court's integrity. This goes far beyond a wealthy developer losing a few holdings. What's unfolding is the methodical stripping away of the Trump Organization's most prized assets. Properties that have shaped the Manhattan skyline and Trump's public persona for decades, now being inventoried, valued, and lined up for seizure to satisfy an enormous civil fraud judgment. Because once federal authorities are placing padlocks on Trump Tower and moving trucks are pulling up outside 40 Wall Street, the idea of legal accountability stops being abstract and becomes unmistakably real. It's staggering to realize that an empire built over half a century, long held up as evidence of unparalleled business brilliance, now risks collapsing because it was propped up by persistent exaggerations about what it was actually worth. Here's the background you need to understand how this escalated so quickly. The roots of this crisis trace back to New York Attorney General Letitia James and her sweeping civil fraud case against Donald Trump, his adult sons, and the Trump Organization itself. After years of investigation, James alleged that Trump routinely inflated property values when applying for loans and insurance while sharply lowering those same valuations when tax bills came due. These weren't small bookkeeping errors. Investigators found that Trump claimed his penthouse apartment was nearly 3 times its real size, valued Mar-a-Lago at more than $500 million despite evidence it was worth far less, and manipulated appraisals across his portfolio with remarkable consistency. The case went to trial in late 2023, and Judge Arthur Ennerin concluded that Trump had engaged in persistent, long-running fraud spanning decades. In February 2024, the court issued a judgment exceeding $450 million with interest and ordered the disgorgement of profits obtained through fraudulent practices. Trump appealed immediately, but this is where theory collided with reality. Under New York law, appealing a judgment doesn't stop enforcement unless the defendant posts a bond covering the full amount plus interest. In practical terms, that meant Trump needed close to $500 million in cash or highly reliable collateral to freeze the collection process. Reporting from Politico in March 2024 revealed that Trump's legal team contacted more than 30 shy companies and failed to secure a bond. The reason was straightforward. Trump's own fraud conviction had undermined the credibility of his property valuations, and no reputable financial institution was willing to accept that risk. And it's important to be clear about what this means. Asset seizures are extraordinarily rare for former presidents. They don't happen to billionaires who genuinely have the liquidity they claim. They happen when courts issue massive judgments, legal avenues are exhausted, and the debtor either cannot or does not pay. Reaching this stage says far more about Trump's real financial position than decades of branding ever did. This is where events took a dramatic turn. Multiple outlets, including CBS News and CNN legal analysts, report that the asset seizure process moved forward this week as New York state attorneys working alongside federal marshals and court-appointed receivers arrived at Trump properties with court orders in hand. At 40 Wall Street, the historic Manhattan skyscraper Trump has long promoted as a cornerstone of his empire, officials were observed entering the building to inventory assets and establish control procedures. At Seven Springs, Trump's sprawling estate in Westchester County, court-approved appraisers were granted access to conduct formal valuations. And even Trump Tower, the gold-clad Fifth Avenue landmark synonymous with Trump's brand since the 1980s, saw legal officials begin assessing how the property could be transferred or liquidated to satisfy the judgment. Trump's lawyers threw everything they had at the wall to stop it. They rushed in emergency filings, arguing that taking control of the properties would cause irreparable damage, not just to Trump, but to tenants, businesses, and employees operating inside the buildings. They insisted the entire case was politically driven, claiming Letitia James campaigned on going after Trump and was now carrying out a personal vendetta. They also argued that enforcing the judgment before the appeals process concluded violated Trump's due process rights. NBC News reported that Trump's legal team warned of impending chaos, asserting that forced sales would depress property values, harm innocent third parties, and amount to an unconstitutional seizure by the state. The court was unmoved. In a written decision issued this week, one legal observers have described as devastating Judge Engoron methodically addressed every argument and dismantled them one by one. CNN legal analyst Jeffrey Toobin, after reviewing the ruling, noted that the language was strikingly blunt by judicial standards. The judge emphasized that Trump was found liable for fraud after a full trial in which he was given ample opportunity to present evidence and defend himself. She made clear the judgment was no ambush. It was the foreseeable result of conduct the court had already determined to be persistent, egregious, and deliberate. On the claim of irreparable harm, the judge was especially direct. Any harm, she wrote, was entirely self-inflicted. If Trump wanted to avoid asset seizure, he could have refrained from committing fraud or posted the legally required bond to pause enforcement. His failure to secure a bond was not the court's responsibility. Then the ruling turned sharper. Addressing the political persecution argument head-on, the judge rejected the notion that New York's Attorney General, courts, and judicial system were engaged in a coordinated conspiracy against Trump. She wrote that the claim was not only unsupported by evidence, but deeply offensive to the integrity of the justice system. She underscored that Trump had received full procedural protections, that the evidence of fraud was overwhelming, and that reframing a legal defeat as political persecution was precisely the kind of bad faith argument the court had come to expect from Trump's legal team. According to MSNBC's legal correspondent, the judge essentially accused Trump of trying to weaponize the appeals process, using procedural motions not to seek justice, but to delay accountability indefinitely. This isn't the first time Trump has responded to serious legal jeopardy with the same familiar playbook. Over and over, the pattern repeats. Fight every step, cry persecution, question the legitimacy of the courts, and refuse to accept their authority. Look at how he handled the classified documents case. For months, Trump insisted the documents belonged to him, claimed he had magically declassified them, and argued the National Archives had no right to recover them. He resisted subpoenas, ignored court demands, and left the FBI with no choice but to execute a search warrant. Even after he was indicted, he framed the case as a political witch hunt, insisting former presidents could keep whatever documents they wanted. Only when criminal charges and the prospect of prison became unavoidable did the messaging shift from, "I did nothing wrong," to, "Maybe it wasn't technically legal, but everyone does it." The same approach showed up again during the January 6th investigations. Trump argued executive privilege shielded him from testifying despite no longer being president. He sued to block the National Archives from releasing records to the House committee and urged witnesses to ignore subpoenas. When criminal charges followed, he pivoted to claiming absolute presidential immunity, asserting that anything done while in office was beyond legal scrutiny, regardless of legality. The strategy never changed. Delay the process, appeal every ruling, declare the system corrupt, and hope time or politics intervenes before accountability arrives. And then there were the Ian Carroll defamation cases. After a jury found him liable and ordered him to pay millions, Trump immediately repeated the defamatory claims online, promptly triggering another lawsuit and another staggering judgment. Each case tells the same story, not a defense rooted in facts or law, but a cycle of denial, deflection, and escalation that only deepens the consequences. When the court required him to post a bond while appealing the judgment, Trump thought that as well, calling it excessive, politically driven, and fundamentally unfair. The pattern was unmistakable. Commit the conduct, deny it outright, attack the accuser, lose in court, claim persecution, refuse to pay, and then weaponize every procedural delay available. This wasn't new behavior born in politics. Long before Trump ever ran for office, this was how he operated in business. Contractors who completed work on his properties would submit invoices only to receive lowball settlement offers or nothing at all. If they sued, Trump's legal team would stretch the cases out for years, burying smaller firms under mounting legal costs until they either settled for a fraction of what they were owed or walked away entirely. The calculation was simple: make fighting him so expensive that surrender felt like the rational choice. That tactic worked when his opponents were individual contractors or small businesses with limited resources. But now Trump is up against state attorneys general and government prosecutors with deep benches, vast resources, and no incentive to back down. Delay no longer creates leverage. Intimidation no longer works. And for perhaps the first time, Trump is experiencing what it's like when the other side can't be exhausted, outspent, or bullied into submission. So, what specifically did the judge say that makes this ruling so devastating? Let's break down the key sections that have legal experts stunned. Reporters who examined the full opinion say the judge dismantled Trump's claims in three major sections. The first focused on the irreparable harm argument. Trump's lawyers argued that forcing asset sales before his appeal was resolved would cause damage that couldn't be undone if he ultimately won. The judge explained that New York's bond requirement exists precisely to balance these concerns. If Trump truly believed his appeal had merit, he could have protected his assets by posting bond. His failure to do so wasn't evidence that the rule was unfair. It was proof that financial institutions, which assess risk for a living, didn't believe his assets were worth his claimed valuations, or that his appeal was likely to succeed. Here's the irony the judge highlighted. Trump was found liable for fraud because he consistently inflated his asset values to banks and insurers. Now he argued those same assets were so valuable that posting them as a bond would cause irreparable harm. Yet when he tried to use those properties to secure a bond, no one would accept them at his stated values. The judge made it clear Trump's inability to obtain a bond was essentially the market confirming his fraud. If his properties had truly been worth what he claimed, securing a bond would have been straightforward. The second section addressed Trump's due process arguments. His lawyers claimed enforcing the judgment before the appeal violated his constitutional rights. The judge swiftly rejected this, pointing out that New York's bond requirement is specifically designed to safeguard due process by allowing appeals while protecting the interests of the judgment creditor. Trump is free to appeal as much as he wants. The bond requirement exists simply to make sure that if he loses the appeal, assets are available to satisfy the judgment. Without it, defendants could strip their holdings during the appeals process, leaving judgment creditors empty-handed. The judge emphasized that this procedure has been upheld repeatedly and that Trump was being afforded precisely what due process requires, nothing more, nothing less thing. The third section addressed Trump's political motivation claims. And this is where the judge's language became particularly sharp. Legal analysts reviewing the opinion noted that she called out Trump's habit of claiming political persecution whenever he faces accountability as tiresome and beneath the dignity of any court proceeding. She made clear that Attorney General James brought the case based on evidence that Trump had a full trial with representation, cross-examined witnesses, and presented his own evidence. The court's findings, she wrote, were grounded entirely in that evidence, not in politics. The judge went further, writing that claiming otherwise wasn't just incorrect. It was an attempt to erode public trust in the judicial system. Courts, she stressed, have both the authority and responsibility to reject such arguments decisively. This leaves Trump's legal team in an extraordinarily difficult position. On one side, they need to continue the appeal of the underlying fraud judgment, but that appeal is now proceeding while Trump's assets are being seized to satisfy that judgment. Every day that passes without a successful bond or stay is another day where properties are being evaluated, liens are being filed, and the infrastructure for potential sales is being established. On the other hand, Trump could try to find a way to secure the bond, but that would mean either convincing a financial institution to accept his assets as collateral, which the market has already rejected, or producing nearly $500 million in liquid funds, a sum he clearly doesn't have despite decades of claiming billionaire status. The problem is that every legal avenue has already been attempted and rejected. His team has gone to appellate courts for emergency relief. Denied, filed for stays, denied, argued constitutional violations. The courts aren't buying it. At some point, the arguments run out, leaving a simple reality. A court found you liable. You owe a massive sum, and if you can't or won't pay, your assets are seized. That isn't persecution. That's exactly how civil judgments are enforced. Legal analysts are noting that this ruling marks a watershed moment in Trump's legal troubles. Andrew Weissmann, former FBI general counsel and a veteran of high-profile prosecutions, told MSNBC, This is the moment when Trump's entire persona as a brilliant businessman and billionaire collides with legal reality. For decades, Trump has portrayed himself as a multi-billionaire, leveraging that image to secure loans, deals, and political credibility. Now, a court has found much of that was fraudulent, and the fact that he cannot secure a bond is the market confirming the court's judgment. This isn't just a legal setback, it's a confrontation with the core of Trump's identity. A Honig, former federal prosecutor and CNN legal analyst, noted that the ruling is striking not just for its conclusions but for its tone. Judges usually go out of their way to appear neutral, giving defendants every benefit of the doubt, especially when those defendants are politically prominent. For a judge to write language this pointed, calling a defendant's arguments bad faith and insulting to the court signals rare frustration and disapproval. It suggests the court sees Trump not as a good faith litigant, but as someone treating the legal system as just another arena for manipulation and delay. A law professor who has often defended Trump's legal positions and even testified for Republicans during Trump's first impeachment acknowledged that this ruling was legally sound. Speaking to Fox News, he said that while he could understand Trump's political arguments about alleged bias, the legal claims his team raised regarding bond requirements and asset seizures simply didn't hold up. He noted that New York's procedures are long established, repeatedly upheld, and applied equally to all defendants, regardless of political standing. Trump, the professor explained, was seeking special treatment, not equal treatment. And the courts were correct to reject his arguments. So why does this matter? Because this isn't just a headline-grabbing legal story. It carries serious consequences for Trump's business empire, his political future, and the broader question of accountability. First is the immediate financial impact. If the asset seizure process moves forward, Trump could lose some of his most valuable and iconic holdings. Wall Street, Seven Springs, and potentially parts of Trump Tower could be seized and sold to satisfy the judgment.
These aren't merely financial assets. They are core pieces of Trump's brand and public identity. Losing them doesn't just hit the wallet. It dismantles the image he has spent 50 years cultivating. Beyond the immediate properties, there's the cascade effect on Trump's other business interests. According to financial analysts who spoke to Bloomberg, many of Trump's properties operate on significant debt. If his marquee properties start being seized, lenders on other properties may trigger default provisions and accelerate debt repayment. Trump could face a cascade of financial crises across his entire portfolio. What starts as losing a few buildings to satisfy one judgment could spiral into a complete collapse of the Trump organization as various lenders and creditors move to protect their interests. Now let's look at what this could mean for Trump politically. His entire political brand is built around being a successful businessman, a dealmaker who knows how to create wealth. Seeing his properties seized to satisfy a fraud judgment directly undercuts that narrative. There's a big difference between claiming the legal system is rigged and actually having your assets taken, because financial institutions refuse to accept your inflated valuations. That's not political persecution. It's the market calling out fraud. Republican primary rivals and Democratic campaigns will certainly seize on this. Images of federal marshals entering Trump Tower with court orders to seize assets are politically powerful and damaging. They reinforced criticisms that Trump's business acumen was more style than substance. Voters who supported him because they believed he was a savvy billionaire may start questioning that belief when they see his empire dismantled under court supervision. Looking ahead to the general election, this creates a concrete, hard-to-spin visual. Trump's usual strategy, claiming persecution, rallying his base, and fundraising off legal woes, faces a challenge when assets are actually being seized. His core supporters may remain loyal, but persuadable voters in swing states may see these seizures as evidence that the smoke around his wealth might reflect a real fire. The institutional implications are equally striking. This case establishes that even former presidents with massive platforms and political influence are subject to the same legal rules as everyone else. Commit fraud, lose in court, fail to post a bond, your assets get seized. Political prominence or claims of persecution do not create exceptions. That principle reinforces the rule of law.
Legal scholars speaking to the New York Times suggest this case could become a landmark example of how courts handle powerful defendants who try to weaponize procedure or politics to avoid accountability. The judge's pointed rejection of Trump's bad faith arguments may set a precedent, encouraging other judges to confront abusive litigation tactics directly, strengthening the system's ability to treat courts as venues for law, not political theater. This situation is creating absolute chaos within MAGA circles, exposing deep divisions over how to respond. Multiple news outlets have noted that Trump's supporters are splitting into sharply opposed camps, and tensions between them are escalating. One faction, led by figures like Steve Bannon and some of the more confrontational MAGA influencers, is framing this as a deep state attack.
They argue that Trump should refuse to cooperate, daring authorities to remove him from his properties and treat the moment as a call for maximum confrontation. On his War Room podcast, Bannon even urged supporters to surround Trump Tower and physically block any seizure attempts. At the same time, another wing of MAGA is quietly confronting the reality of Trump's legal troubles. Reporting from the Bulwark and other outlets shows that some Republican strategists and former Trump administration officials are privately acknowledging that his failure to secure a bond highlights serious issues with his actual finances. They worry that the image of Trump as a savvy, successful businessman is being dismantled in real time, and that the fallout doesn't just hurt Trump personally, but threatens the entire Republican brand that has long leaned on his persona.
Then there's a third group trying to straddle the line, claiming the judgment is unfair and politically motivated while also suggesting Trump should have settled years ago or found a way to post the bond. Some Fox News commentators fall into this camp, attempting to criticize the process without fully endorsing Trump's choices. But that middle ground is becoming increasingly untenable as asset seizures move forward. Tensions escalated further when Trump himself took to Truth Social, posting in all caps to call the judge corrupt, label the attorney general a political hack, and claim that Democrats want to do to all successful conservatives what's happening to him. He's trying to frame his personal legal and financial disaster as a broader political narrative of persecution. The problem is that the facts keep undermining that narrative. It's difficult to claim persecution when the evidence shows decades of systematic fraud, and the only reason assets are being seized is because no private institution will underwrite a bond using those same assets as collateral. The reality doesn't bend to rhetoric. Meanwhile, Democrats are taking a measured approach in their public response. Rather than celebrating, they're letting the legal process tell the story. Politico reports that Democratic strategists believe the image of Trump's properties being seized is so powerful it doesn't need spin. Voters can see the reality and draw their own conclusions. Over-celebrating could even feed into Trump's persecution narrative, so they're largely staying quiet and letting the visuals speak for themselves. But this goes far beyond a single judgment or a few properties. It raises the question of whether the legal system can actually hold powerful individuals accountable for fraud, or whether wealth, political influence, and a loyal following create a kind of immunity. If Trump can commit systematic fraud for decades, build an empire on inflated valuations, run for president on that record, and then avoid consequences by claiming persecution, what does that signal? It tells every fraudster that with enough power and noise, the rules might not apply to them. This isn't just about Trump. It's about whether financial fraud carries real consequences, whether court judgments are enforceable, and whether the wealthy and politically connected play by the same rules as everyone else. The judge's ruling and the ongoing asset seizures are providing a clear answer. No one is above the law. Political support doesn't shield you from accountability. And if you can't post a bond because no one believes your asset valuations, that's the market speaking, confirming the fraud, not enacting persecution. Here's the bottom line. Donald Trump is now seeing federal marshals start the process of seizing his properties to satisfy a massive fraud judgment. The judge in the case didn't just reject his legal arguments, she shredded them, labeling his claims frivolous and insulting to the court. This isn't merely about losing some buildings.